I'm constantly getting emails and questions from good people asking me, how is all this legal? How could the government be allowed to take over health care? There are limited, delegated, and discrete powers of Congress in the Constitution. Stay with me on this and take a quick look at them. This is directly from the Constitution itself. The Congress shall have the power to lay and collect taxes, to pay debts, to provide for the common defense and the general welfare of the United States of America as a country, to borrow money, to regulate commerce with foreign nations and among the several states and with the Indian tribes, to establish a uniform rule of naturalization, to coin money and regulate its value, to provide for the punishment of counterfeiting money and securities, to establish post offices, to promote the progress of science and useful arts, to constitute courts inferior to the Supreme Court, to define and punish piracies on the high seas, to declare war, to raise and support armies, to provide and maintain a navy, to make rules for the government and the regulation of the Army and the Navy, to provide for the calling forth of a militia, to provide for organizing, arming, and disciplining the militia, to exercise exclusive authority in all cases over the District of Columbia, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. That is it. These are the limited, delegated, discrete powers that the Constitution gives to the Congress. So how can the government take over health care and still comply with the Constitution? Joining me now in Washington are Tim Lynch, director of the Project on Criminal Justice at the Cato Institute, and in Virginia Beach is Jay Sekulow, chief counsel of the American Center for Law and Justice. Jay, first to you. I guess
yes,
if we were to ask somebody from Congress that had actually read the Constitution, they would say that their authority to regulate health care comes from the Interstate Commerce Clause, the power of Congress to regulate interstate commerce. But when the founders wrote that word regulate, didn't they really mean to keep regular, to make sure there is commerce between the states? What do you say?
You're absolutely right. And, Judge, I had a feeling you were going to ask me that. And as a good lawyer that litigates before courts all over the country, I was going to also let you know that if they would read their own legislation, you know what's missing? The word Commerce Clause. It's not even in the bill and the various bills that are being proposed. So they don't even pretend to rely on the Constitution. Rather, what they're doing is a policy of social engineering under the guise of legislation, and they'll come up with theories about constitutional analysis. But at the end of the day, you're absolutely right. To say that the healthcare industry can be taken over by the United States government under the Commerce Clause or any other provision of the 17 enumerated powers you just mentioned is incorrect as a matter of law and unconstitutional in our view as a matter of strict constitutional law. Period.
Tim Lynch, I suppose that if I went from one part of Manhattan to another to visit my doctor, I'm obviously not crossing any interstate lines, I might be able to argue that there's no interstate commerce involved. But the Congress and the lawyers that the Congress would hire, and maybe even some judges would say, well, let's see. The doctor that you went to medical school outside of New York, and the medicine that he gave you was actually made in New Jersey. And so because he once left New York and the medicine came from New Jersey, there's interstate commerce involved. Now, as ridiculous as this sounds, is it not the case that these are the types of arguments that the government has made and that the courts have accepted when trying to justify abuse of the Constitution, where Congress wants to regulate anything that moves?
Yes, unfortunately, it's true, Judge. Attorneys do go into court to make those kinds of arguments. But the bottom line is, I agree with you. Let's be clear about this. The Constitution does not authorize the federal government to establish a public health care system like the one that they have in England or the one that they have in Canada. There would have been no reason to lay out those specific grants of power that you rattled off if the Constitution authorized Congress to establish whatever policies and programs they thought would be in the best interest of the country. There's no reason they would have laid that out. They laid out those specific powers because they wanted the federal government's powers to be limited, and they wanted the federal policymakers to focus on those limited tasks. But the key point, I think, for your viewers is that the Constitution is incapable of enforcing itself. If members of Congress choose to ignore the Constitution, then it falls upon the people to exert pressure on Congress. Somebody once said, Congress it's only when Congress feels the heat that they see the light. So if people want to make their voices heard, they need to exert that pressure on Congress. But if the people become apathetic about the Constitution and their freedom, then the rule of law and their liberties will erode, and there's already been too much of that already.
Jay, you know the Constitution as well as any lawyer I know. And not only are there only those 17 powers that I enumerated, but there's a couple of backstops in there. There's the 9th Amendment that says the fact that we have given these powers to Congress doesn't mean we've taken anything from the people. And there's the 10th Amendment, which says what we did not give away, we retained for the states. That nobody talks about those anymore.
No, and you know what's interesting? I actually had a case, Judge, at the Supreme Court that involved the Commerce Clause provision. And the lawyers on the other side of this particular case were arguing that transportation from a public sidewalk to the door of a business constituted interstate commerce for the purpose of regulatory and federal legislation. Now, the court disagreed with that. But Tim said something also, and it follows up exactly what you said. You've got to, the American people need to be continuing. I'm glad that you're doing this and Glenn's continuing to do this, to speak out on this, because you're right. The 10th Amendment to the United States Constitution, as well as the 9th, but the 10th in particular here, says, look, we're not giving everything to the federal government. The states have authority here, and here's the problem. At the end of the day, Congress is not even thinking about where are they getting the authority to do this. This is a social engineering job at the end of the day.
Guys, I want you to stay with us. More with my guests coming up next. Back again are Tim Lynch, Director of the Project on Criminal Justice at the Cato Institute, and Jay Sekulow, Chief Counsel of the American Center for Law and Justice. Tim, to you. Okay, so to regulate interstate commerce means to keep it regular, to make sure it flows easily, that New Jersey can't impose a tariff on something coming in from New York or Pennsylvania. But isn't there an area of human behavior, of commercial intercourse, if you will, where the Congress has not kept interstate commerce regular? The Congress has actually allowed the states, has it not, to prevent insurance companies from operating in one state and in another, and thereby kept the insurance companies that are in state captive and given them a preferred role and told people that live there you can only buy from these insurance companies. How did that happen? Tim.
Yeah, that's a perfectly good example of the proper role for the government, because the state governments are preventing us from purchasing health care policies that are being offered by companies in other states. This is where Congress should be acting to free up the market in health care policies. But unfortunately, Congress is moving off in the other direction, and so the problems are going to be exacerbated instead of solved.
Jay, when members of Congress are debating legislation, you've been there, you know how the government works. Do they actually look at the Constitution to see if what they want to do is authorized there? Or do they just say, you know what, this is what I think is right, government knows best, the heck with it, we'll let the courts decide if it's constitutional?
You know, Judge, some of the members do, because some of them take it very seriously. I could rattle off some that you know and I know that do take the Constitution seriously and take the role as legislators seriously. But I'll tell you this, that one of the first questions I get asked at the Supreme Court of the United States when I'm defending a statute, and we've been in that position before, they will say, what is the constitutional grant of authority for this legislation? Is it the necessary and proper clause? Is it the Commerce Clause, as we've been talking about? Unfortunately, Congress ignores that oftentimes. And while the Supreme Court has expanded the role of government over the last 40 years, the fact of the matter is, from time to time, the court realizes, wait a minute, Congress really shouldn't be engaging in this. And frankly, I think, Judge, that this situation right now, as it relates to health care reform, is exactly that. In fact, I'm hopeful that the American people are going to continue to speak up, and that they're going to beat this back, and the legislature is going to say, and the Congress is going to say, we're not going to do this. But if they do, we're already looking at that lawsuit, and it's going to focus like a bullseye, as you just said, on the Commerce Clause and the lack of constitutional authority for this legislation in the first place.
Thank you. Tim, here's a question I get all the time from people that are frustrated by this. Why can't I file a lawsuit? Why can't I just sue the Congress and get the courts to invalidate it? Because the Constitution has put obstacles in our way. Say again?
Challenging like a health care proposal in the Congress?
Right.
The way the Constitution was set up is they expected each branch to take their constitutional responsibilities very seriously. So they put a stop to unconstitutional proposals in the Congress. If it happens to get out of Congress, they expected the president to veto any unconstitutional legislation. And then if it were to get the president's signature, they wanted the courts to enforce the Constitution. But as I said earlier, in some respects we've drifted away from it, and it's up to the American people now to exert pressure on members of Congress if they're ignoring the Constitution. That's the only way we're going to keep the charter of our liberties alive and well. Otherwise, it's just words on paper.
Got it. Tim Lynch, Jay Sekulow, thanks very much for discussing the Constitution with us.